there's a hand. Sinago, yes. Yes, Sinago, you may proceed. Unmute yourself and ask the question. Yes, I've gathered as much. I don't know what's happening. I was just going to tell you. We had online court today, and I'm busy doing a trial, and the judge couldn't see me, and I had problems, and then I was kicked out and on. So I'm so nervous about this not working out tonight, but let's see. So far, so good. It's just that I can't seem to turn on the camera. And it is actually turned on, but for some or other reason, you can't see me. But you can see the slides that I'm sharing.
Yes.
Okay, then that's fine. That is as much as you're supposed to be able to see at this stage. But as soon as I can, I will make myself visible so that you, at least when you see me in court, that you know who I am. So welcome to High Court practice. For some other reason, you've decided that you want to be a legal practitioner, and you're well on your way there. You finished your LLB. Can you hear me?
Yes, we can.
Oh, it seems like there's something happening on my screen. Okay. Let me just see. What's this one? Why do I have two windows? Let me close the one. I'm still here, yes. Right. So you have decided that you wanted to be a legal practitioner, and now we are here. I understand from Zukiswa that we are 390 students in this class. That is a lot. Yes, there's another hand, Patrick Radzuma. Yes, Mr. Radzuma. You can ask your question.
Can you hear me now?
Yes, I can.
Yes, I'm saying I can't see the slides. I'm not sure if it's only me, but I can see on the chat as well. Some people are saying the same.
We can see,
I can see the slide.
Please log out.
I can see the slides.
I'm so scared to log out here.
No,
can somebody
no,
see
we can see your slides.
We can see the slides. We can
okay,
see
so if some people can see, then it's not my fault. Then it is on your side. Because if some people can see, then it's not my fault. Then it's your side. I'm not going to take responsibility. I am so scared to get out of here, because, like I tell you this afternoon, the court started without me. So that is how impatient judges get when you do these online courts. Those of you in Gauteng, you know that we have online courts sometimes. It's at the discretion of the presiding judge, and if the parties makes an application, you can't see the slides. Okay, there's many of you who can't see the slides. Okay, I'll put the slides off and then I'll put it on again. That's much I'll do.
Advocates, they should log out and log back in.
Okay. I can't even stop sharing.
Sorry, advocate. We have these problems every now and then, and people know that when they have this issue, they should log out and log in.
Yeah,
so we can see the slides. No, please. I'm saying that we have this issue often, and people know that they should just log in and out. So it's not your issue.
Well. We've also done it. We've logged out and logged in.
And we still can't see the slides.
And we still can't see
okay,
the slides.
I've stopped sharing the slides. So those of you who could see the slides, you can't see it anymore. Am I correct?
We can still see it.
Oh, you can see
it on my side.
I've stopped sharing, so it's doing something which I have absolutely no idea what it's doing and why it's doing that. This is going to be it. We are going to struggle this week with technology. we are going to struggle this week with load shedding, but we are still going to keep on, and we're going to try and do as much as we can of what we're supposed to do. It's not going to be without challenges, but I do just hope everybody is patient. From my side, I've stopped sharing, but you say you can still see. So I'll just give it a moment because it's going very, very slow here. Something happening and it's very, very slow. Okay, so why is this course important to do? This course is very important because you need to pass High Court practice as one of your modules to become an attorney. You also are doing this course to get your 6 months discount to get a year discount of doing articles. That is if you are lucky enough to find a principal who will allow you to do the 1 year, because I hear from people that principals say they don't want to take on candidate attorneys who's just doing a year. They want you to do 2 years because, yeah. Okay, can you see the slides, everyone, or no one can see it? Because no one must be able to see it.
I can still see it.
We can still see the slide.
Nothing changed, Advocate. We can still see.
Is it?
Yes.
Some of us
that's
can.
going.
Some of us
Because
can.
I'm not sharing it anymore. I'm not sharing it anymore.
Yeah, I cannot see it.
Okay, I'm not sharing it anymore. So let me just do the introduction and let us do as much as we can, okay? For those of you who can't see it, you're not supposed to see it now because I've taken it off, but for some people it still remained.
Advocate,
Right. Yes.
the slide was shared with us, so I don't know if we could follow on our own independent downloads, and then you just tell us
You
which.
You could do that if it is helpful to you. Look, the slides, I'm going to talk about the slides now. Let me just do what I intended to do so that I don't get distracted. Right, so I said this subject is important because this is part of module 2.1 of the legal practice curriculum, and it is intended to take you a step closer to qualifying as a legal practitioner. Right, so apart from attending this training, you will also need obviously to serve your articles, and yeah, then you will become an attorney, or if that is the route that you want to follow. Some people do this course, but they have no plan to become an attorney, that I've heard and seen over the years. Right now, when you do this training, it is assumed that you know the law, that you have acquired the subject-specific substantive knowledge when you were doing your LLB. Okay, so what you studied at university, I'm not going to explain that back to you. At some instances, we will deal with certain substantive issues, but this is procedural law. You've done procedural law at university also. You've done civil procedure. This is only civil practice in the High Court of South Africa. Okay, so we are going to concentrate on the High Court, but I can at this stage tell you, and for those of you who are in practice, you would know this, that the rules that applies in the High Court, the uniform rules, word for word, those rules you will see in the Magistrates Court rules as well. So if you know it for the High Court practice, you will know it for the Mag Court practice. It is the same rules. The only difference is it has different numbers, because in the past, Magistrates Court rules were different. And when they adopted the High Court practice, the uniform rules of the High Court, they retained the original numbers in the Magistrates Court. But the wording, if you check it, you will see it's word for word the same in most cases. I would say in 95% cases, it is exactly the same. So it is a good thing because you get me to go through High Court practice, and then you will get someone else. I think it's Advocate Pitt, if I'm not mistaken, who will take you through the Magistrates Court rules. So not rules, Magistrates Court practice. Right. Now, you will see that this is a practical course. And a lot of people, even people that are in practice, they say, but how can you teach a practical course online? The answer is, I don't know, but we are doing it. We've been doing it for a couple of years. I don't know if it's working. That only you can decide if it's going to work. It's supposed to be practical. You're supposed to be doing things. I'm supposed to tell you how to do things, and you're supposed to do it. But for this part, you're not going to be physically doing stuff. I'm going to tell you about stuff. I'm going to give examples because I've been in practice long. I'm an advocate and a member of the Johannesburg Bar. I'm a practicing advocate for 21 years so far. So I have been around. So I know some things, not because I'm clever, but just because of the experience that I've gained over the years. Some things I don't know, I still get it wrong. And a lot of times I am enlightened by students who tell me, no, it is like this, and this is how it happens, because I maybe don't do that kind of thing a lot. So we learn from each other. That's one of the reasons why I keep on doing this, teaching this class, because I learn from it. I am also teaching this class on one-on-one basis, where we have a classroom. You remember that this class you can do at in Cape Town, at Pretoria, in East London. So I teach at the Cape Town School for Legal Practice, and I have been teaching there this exact course since 2006, so it has been a couple of years now. You have received my slides from Zukiswa. Now, my slides is my slides. It's not the school slides. And I'm saying this as a disclaimer. It is not 100% correct. The laws change so quickly. We had huge amendments to the uniform rules last month in June. A lot of amendments. And I'll deal with that amendments when we get there. But the slides won't show it yet because I haven't updated it yet. So the law is dynamic and it changes. And I've started the slides when I started out, and I've just enhanced on it, took some things out, put some things in, and it's a working document. So, and it is basically just for me so that I don't lose track of where I am in telling you what the syllabus is. You also have your manual. Now, your manual is the most important document. When you are going to write your exam in this course, your BBST, Broad-Based Skills Test, yeah, you can take in your manuals. It's an open book exam. So you take in your manuals, but you must know where to find things in that manual. And you must basically understand so that when you are asked a question, you know exactly what you must look for in the manual, so that when you draft your answer, you will draft it correctly. For those of you who have looked at the manual, you will see that at the back of it, there are forms and precedents. That is where there's a lot of examples of a lot of applications and actions and other kinds of notices that you will need. So it's a good thing to affiliate, to get familiar with what is in here so that you know. And when you get to the exam and they ask a question, don't be the one who struggled to draft something when you could have just looked in your manual. Because you take in your manual, you take in all the manuals of all the courses that you're going to cover when you do your BBST exam. Right. Can the people still see the slide, that thing that I think I'm not sharing? Because I'm going to start sharing it now.
Yeah.
I'm going to start sharing it now again. I don't know why I'm having such huge problems this week with this computer. I think I must throw it away. Anyways, for those of you who've seen it and those of you who are following it, you would see Lady Justice, right? Do you see it? Now, Lady Justice represents the law as we apply it. Remember, this is now the practical legal practice and how we practice law and what is required of us. So there is some symbolism in this picture that I've got. Those of you who are following it on your own, there is symbolism. Now, the first symbolism, the first thing that you immediately see is the blindfold. Now, I'm not what does the blindfold represent? I'm just going to tell you. The blindfold represents justice is blind, that judges must be impartial when they pronounce judgments. They must not take sides and they must not favor anyone. So they must be blind and they must only hear the matters that is before them. Right. If there's anyone else that has another interpretation of that symbolism, you can tell me now or later. Right, the next thing that you see is the scales. Now, you would remember in civil procedure, the burden of the standard of proof is on a balance of probabilities. Right, so you must balance the rights. The court must balance the rights. So if there are two parties, and we know that sometimes there are more, but let's assume that two parties, you would then put each side on all the evidence led by the one party on the one side and the evidence led by the other party on the other side. Right. And then you would wait and try to bring the balance in equilibrium so that balance is restored. That is what the scales represent. It also has two sides, which is one of our rules of natural justice that we apply. And that is the aude alteram partem rule. Now, we do know that the aude alteram partem means that you must listen to the other side. Now, the court, before it pronounces on judgment, can't just hear one person's version and make a decision. You must listen to the other side, put it in the scale, and then try to balance the scales. That is what that represents. Another symbolism is the sword. Justice is swift. You will see it's a double-edged sword. They will deal with you swiftly. We know in South Africa that is not always the case, but we do know that it does. They will deal with you. Swiftly is a relative word, I think. For some people, it can take long, can be quick. Then the last symbolism. Is there anybody that can maybe help me out there? There's something else. And the reason why I'm asking is because people always...
Can I try?
Yes, you may.
I think the last symbolism is the woman, because the law's there to nurture and protect. And just like women or mothers would nurture and protect their infants, so is the law there to protect everybody.
You know, I never thought of it like that. It's the first time I hear that. The law is there to nurture and to protect. And that is actually correct. I've never thought about that. That was not what I was looking for, but you are not wrong. Okay, thank you. Anyone else that want to take another step? That is a very good answer. That want to take another step?
Can I try, Advocate?
Yes, you may.
Yes, Advocate. I see the Lady Justice is standing on something like a stoop, but I don't have the interpretation of that.
Yes, on a pedestal, kind of. Nobody is above the law. The law is higher than everybody else. Yeah. And we know that in South Africa, they take presidents and all kinds of people to court. Nobody is above the law. That is the answer that I was looking for. But yeah, if there's anything, somebody that I may have missed. Okay, there's some main things that it is. Yes.
Sorry, Advocate. Just on the pedestal.
Sorry, yes.
Just trying
What
to
is it?
remember something that was said by Justice Mogoeng at some point, where he said something in the lines of justice must not only be seen, but it must be seen to be done. So I think if you put it on the pedestal, then you're putting it up there to be seen, and it must be seen to be done.
That is another interpretation that I didn't know. Okay. So because of it's higher than, say, yeah, the normal person, it's on side, so it must be seen to be done. So it must be visible, eh? Yeah. Very
Yes,
good.
ma'am.
Very good. Anything else?
Yes, Counsel, if I may.
Sure.
The sword that Lady Justice is holding in her right hand, it can show that she strikes down upon injustice, alternatively that she can cut through obstacles to get through the facts of each and every single matter.
Very good.
Can I add on that point?
Yes.
The fact that it's facing down and not facing up, because if it was facing up, it would be attacking. And the fact that it's facing down is that it's not there to attack you.
Okay.
So like the law shouldn't be.
So it's not going to attack you, but facing down and how she holds it, she can use it quickly, isn't it?
Yes.
I don't know. Okay. Yeah, there's a lot of things that I didn't think of. Thank you for that. Right, so let's move on unless there's other questions. And please, if you do have a question, just ask it because I'm not seeing you on my screen. So I'm hearing you, but I'm not seeing you. For those of you who can see the slides, did you now see me change to another slide? Or are you stuck on the lady?
No, I'm on the lady.
Oh, so then it's like stuck there. So you can't see anything else. Okay. Right. The next slide that I have is the one where there's a quote of what the practice of law is. I just put it there because I like it. You will find that physical attributes are of no consequence where the battle is one of intellect. Intellect, voice, personality are all weapons in one's armory, but to none can be ascribed any degree of dominance or even of importance. There is, however, one quality that can overcome any physical failing, and fortunately, it is yours for the taking. Sorry. Fortunately, it is for yours for the taking. It is the quality of being conscientious and diligent. Okay, so basically what it says in 1969, Morris in Technique in Litigation said that anybody can be a good lawyer as long as you are hardworking and you are diligent. So how do you survive by being hardworking and diligent? Conscientious means that you know your matters, you know your cases. When you do a matter, when you are given a matter to do, you see that you know all the facts, you see that you know the law, and this is not rocket science. It's just that you must familiarize yourself with the facts. You consult with your clients and you ask all the relevant questions. You look at the law, and it is very easy to find the law, and you see what law applies to your facts. And that is when you get to court, you will be, first of all, confident because you know your facts, you know the law, and you will be good as a lawyer, irrespective of whether you have intellect, of a good voice, with a personality. That is very good to have. Many people have that, and they are brilliant lawyers. But that is not the only one or the most important one, because you can have all of that, but if you don't know your matter, then you're not a good lawyer. So this is for every one of us can achieve that. Okay, I'm moving on. Now, again, going to the manual, is there a question? I'm hearing a sound. Going to the manual again, you will see that I do what is in the manual, but it is a slightly different format than the manual. There's somebody whose microphone is on and it is disturbing.
Lisa?
Yeah. Okay, so I'm going to jump around in the manual, but I'm going to do exactly what is in the manual. So for now, I am on par with what is in your manual. We're going to do the sources of the High Court practice. And the first source of High Court practice, this is practicing in the High Court, is the Superior Courts Act 10 of 2013, as well as the Uniform Rules of the High Court. Okay. Now, the Uniform Rules of the High Court applies throughout South Africa. That rules to all the high courts. You can see the name Uniform Rules. At one stage, the different divisions had their own separate rules, and then the rules board came together and they united, they uniform, made it uniform so that it applies across the board to all the courts. And these rules are there so that the court runs smoothly. So it is rules that we must follow in order to get our case before the court. If we follow the rules and our opponents follow the rules, then our case will get to court timelessly and without much problems. Then we can look at the substance of our cases. And we are going to concentrate on the process of getting your matters to court. That is why I said we assume that with your LLB degrees, you already know the substantive law. So the uniform rules, because it is there so that the court can run smoothly, if you do not comply with one of the rules where you were supposed to comply with the rule, then the court can condone you not complying with the rules. The court can say, no, it's okay that you didn't comply with that rule, but the courts only do so if you apply for the court to condone it, for condonation. And when you bring an application for the court to condone you not complying with the rule, then you must give the court a good reason. The rule says you must show good cause, a good reason as to why you should be allowed not to comply with the rule and why you should be allowed not to be punished. And how does the court punish in civil matters, punish litigators in civil matters? By making a cost order against you if you didn't follow the rules. Okay, so the court can condone the non-compliance of the rules, but be careful. You might get the cost order against you for wasted costs. If your opponent is being prejudiced by you not applying the rules, the court can make a cost order against you for wasted costs. And that is not good for your client. Remember, we always act in the interest of our client when we represent them in court. So we want to keep the costs for them as low as possible. We don't want to incur unnecessary costs. Right, so just remember that about the rules. If you did not, for one or other good reason, comply with the rule, you can always ask for condonation. The next source of high court practice would be practice directions. Now, what is practice directions? Practice directions is those directions or directives, as they call it, in the various provincial divisions that the judges precedent from time to time issue. It contains important information about that specific division only. So this is not across the board applicable to each and every division, right? And when I talk about the division, I'm talking about high court divisions. So practice directives are issued by the judge president of a specific division, and he then tells you how you must act in relation to matters that is in his court. For example, a good example is in Gauteng, you have virtual hearings. In other parts of the country, you do not have virtual hearings. So there is a lot of practice directives as to how virtual hearings should be conducted. They don't need that in other divisions, so they don't have that. Right. To give you more of an idea as to what is in practice directives, the next slide tells you what it is. It says that the practice directives will have the court times and the sitting. It will tell you what the documents and pleadings must look like. Also tells you motion court and the fast lane. The fast lane in inverted commas here, it means matters that are heard out of turn. If you have to go to court, if you need relief on an urgent basis, you cannot wait for your turn. You can't go back in the queue at the back and wait till you come to the front. You want to go in front of, you want to skip the queue, you want to go in front of everybody that's already in the queue. That is the fast lane. That is urgent matters. Now there's rules relating to that. Motion court is where applications are heard. Unopposed motions and opposed motions. Also, the practice directives deals with trials and other opposed matters, and appeals and heads of arguments, and then criminal matters. Right. Whilst I'm talking to you, I am trying still to upload. I don't know what's happening here. I just can't seem to do that. Right, going to the next slide. We're still with the sources of the High Court practice. Another source, that is where you get information as to how to practice, it is in the textbooks and the electronic sources. Right? So the normal textbooks that you must have used at university, civil procedure in the Supreme Court, there's Erasmus, that big loose leaf book, Herbstein and Van Vincent. There's a question, does the practice, where's the question now? I can't see the question. Does the, who asked the question? It came up and I could see only. For that person, NM, don't be shy, nobody can see you. Okay. Oh, okay, fine. Does the practice directions of a provincial seat have to be followed in the local seat? Yes, it does. Okay, let me at this stage tell you about provincial and local seats, because we're going to get there at some point, but let me tell you now. In some divisions, there are provincial seats. There are more than one high court. In some provinces, there are more than one high court. For example, in Gauteng, there are 2 high courts. In KwaZulu-Natal, there are 2. In Cape Town, there's only 1. Mpumalanga also has 2. And I think Northwest have 2. Northern Cape has 1. Eastern Cape has 5. Is it 5 or 4? 4 high courts. Right. Now, in every province, one of those courts where there are more than one of the courts is a provincial division, right? And the other courts are all local divisions. Now, provincial division and a local division, what is it? Is it different? No, it's not. Imagine yourself that you have a court, and then because there's another town in the same province, and so that people don't have to travel to this town, you send some of the judges to go sit there. That is the local division. They are all judges of the same stature, the same rank. All of them are judges. And the one is just an extension of the other, a satellite of the other. But the local division only have jurisdiction, that is the ability to hear a matter, in a specific geographical area, the local division. Whereas the provincial division would have jurisdiction over the whole of that province. For example, KwaZulu-Natal, Pietermaritzburg has a provincial seat, So Pietermaritzburg, whenever anything happens in KwaZulu-Natal, you can go to the Pietermaritzburg court. Even if it happens in Durban, you can go to the Pietermaritzburg court, because Pietermaritzburg and Durban has concurrent jurisdiction over that area. If something happens in the Durban area, in the area that is covered by the jurisdiction of the Durban local division, then you can institute proceedings in the Durban High Court, but it is only in a specific geographical area. Now, the same with the ones in Eastern Cape. Now, you would think, why does the Eastern Cape have such a lot of courts? It's just a simple explanation of our history. We had independent states in the past where they had high courts. That high courts remained there. So when we all became South Africa, the high courts were still there, and they just kept it on as local divisions of the provincial division, which is in Grahamstown, or as we call it, as it's now known as Makanda. So they have a high court in Grahamstown, the provincial division. Then they have local divisions in Port Elizabeth, Gqeberha, Mthatha, and Bhisho. Those are local divisions. Now, the local divisions only have in a specific geographical area, whereas Makanda will have over the whole of the Eastern Cape. So they have concurrent jurisdiction over that small area. Yeah, I don't know if I explained that appropriately for the one who asked the question. Napi. I hope I did. Yes, I am now on slide 6. And I'm still trying to share with you as we go on, but it just doesn't work. Let me go to the textbooks and electronic sources is also a source of high court practice. Textbooks, I've told you about that already. Slide 7, the common law is also a source of high court practice. Now, what is the common law? The common law, as we know, we hear a lot about the common law has to be developed in line with the Constitution. So if the common law has some aspects of it that is unconstitutional, people challenge it and then they develop it so that it meets our constitutional democracy and all of that. But one of the common law principles that we had was the inherent jurisdiction of the Supreme Court. It always had inherent jurisdiction. That means that the Supreme Court can do anything that is not illegal. If you can go to the Supreme Court or the High Court, and you can ask for any relief as long as it's not illegal, the court has that inherent jurisdiction to give you that relief. Okay. So as a Supreme Court, they can do that. How do we, on everyday basis, apply this inherent jurisdiction? How do we, yes? Did somebody ask anything? Must I switch off my camera? Can you see me now? No, you can't, but I'm switching it off. Okay. So if you've ever seen pleadings, particulars of claim, or even a notice of motion, now you know the part where we ask the relief, that is called the praise. And sorry if you already know this, but I'm just speaking from a point of view that you don't. So that is called the praise, what you pray for the relief. Now in that, you will see one of the praise is always further and or alternative relief. Now what that means is that the court, you're asking the court to give you further relief or alternative relief, even if you did not ask for it. You have your specific praise for the relief that you want, and then you include this prayer. Now, because the High Court has inherent jurisdiction, it can give you relief that you didn't ask for, but that you've demonstrated that you made out a case for. Okay, we all know that you don't ask for further and alternative relief in the Magistrates Court, because the Magistrates Court is a creature of statute and doesn't have inherent jurisdiction and cannot give you anything that the Act doesn't allow, whereas the High Court can. Okay, I'm changing slides. I just hope my slides corresponds with yours. This is just a reminder that Section 173 of the Constitution has actually now, I said that under common law, but it has actually now codified the inherent jurisdiction. It gives the Constitutional Court, the Supreme Court of Appeal, and the High Court the inherent power to protect and regulate their own process and to develop the common law, taking into account the interest of justice. Moving on, another source of High Court practice is case law. Looking at case law, we have case law in the law libraries, in the law books. What do they call it again? Law reports. I don't know if people still go and look at law reports, but those of you who have access, you probably would. Otherwise, we check on Safely, and then there's, for those who can afford it, there's Tutorstat and LexisNexis and all other kinds of sites that you can pay for and have access to the law reports and how the law has been applied to certain facts. Very important if you're going to represent somebody with similar facts, then you can use that case as persuasive value, or even if the court have to follow it, you can tell the court that it has to follow it. Yeah, the next couple of slides deals with the courts. I'm not going to say much about that. This is actually basically self-reading. Supreme Court of Appeal, here's appeals, and then the Constitutional Court. Here's constitutional matter. I'm moving very quickly. For those of you, if you look at the in your manual, you will see an act of the list of all the courts that they have, high courts that they have in South Africa. So it would have the provincial seats and the local seats of that courts. I've already explained to you concurrent jurisdiction, so I'm not going to do that again. Right, I'm now on the slide 14. I hope our numbers correspond. This is the one that have the emojis on it. Yeah, right. So taking you back to our very first picture that I said we must interpret the symbolism, we are coming there again. The principles that underlie the law of procedure in the High Court. First of all, an independent and impartial judiciary, the blindfolds, right? What does that mean? It means that a judge, when he sits and hears a matter, he must consider evidence, right? And what is evidence? So the evidence is what we place before the judge, and when I say we, I mean legal practitioners, you place the relevant evidence before the judge for the judge to consider. If you don't place the evidence before the judge, or if the evidence is not correct or placed before the judge correctly, then the judge cannot consider it. Is there somebody that has a question?
I think my charger.
Okay. Thank you. Right, so the judge must consider everything that we put before him. Then once he has considered it, he writes a judgment. Now in his judgment, he must motivate his judgment. He must state in his judgment why he accepts certain evidence. And if he don't accept evidence and he rejects it, he must state why he rejects certain evidence. So it's important for it. So the judge must look at the evidence, consider the evidence, give a judgment, and motivate it. And obviously, if we're not happy, then we're going to take that matter on appeal or a review. Right. The next principle that underlies the procedure in the High Court is the one of equal opportunity, the scales. Now, the principles for equal opportunity is, firstly, all proceedings in principle must be in public, an open court. We have exceptions to the general rule where we have matters heard behind closed doors in camera, where youths are concerned, where there was an application because it offers, the charges are of a sexual nature. But in principle, all matters are in public, so the public has the right to have access to it, to go into a court and to sit and listen. I think recording court cases by television stations and that, it's an extension of that right, that in principle, all proceedings must be in public. It's just that on a bigger platform, more people have access to watch proceedings, because proceedings must in principle be in public. And then the next principle that of equal opportunity is the audi alteram partem, which I alluded to earlier. The defendant is always notified of the nature of the case, and he's always afforded the opportunity to come to court and to defend or oppose whatever proceedings has been instituted against him. Right. Now, how does this happen in practice? In practice, an independent party called the sheriff, who is appointed by the boards of sheriff, he has this function. In all matters, the first process, if it's an action where we use the summons, or if it's a motion where we use the application where we use the motion, the first one must be served on the defendant or on the respondent by the sheriff. The sheriff then completes a document, and the document then will include information as to how it was served and who it was given to. And only once, in the event that the defendant does not come to court and the plaintiff is there, or the applicant is there and the respondent is not there, the court must first see, did the defendant get notice of this matter? And if it is clear from the return of service completed by this independent person, the sheriff, that the person had notice, then the court can then go ahead in his absence and say the fact that he's here means he agrees with whatever relief it is that you're asking, because here he's been notified that he can come to court and he can come and defend it. That's how we apply the audi alteram partem. The defendant must always be notified of proceedings against him and what it is about, and given an opportunity to come to court. Do I have any questions so far? Yes, the question by Michelle Louise Talliard is for a notice of motion, does it have to be served by the sheriff or can it be served by an attorney? Okay, so you probably have a reason why you're asking this. But like I already told you now, the first process, thanks to Kiswa, the first process must always be served by the sheriff, right? There are instances where you have a main action going and then you have ancillary applications. In that case, that ancillary application, which means it is about things that are happening in the main action, that don't have to be served by the sheriff because the main action has been served by the sheriff. For example, it's a delictual claim they're claiming damages for negligence. And the sheriff served the summons. Right. Now it's time for discovery, and a notice of discovery is sent to the defendant, and he doesn't discover. The plaintiff can now bring an application to compel him to discover. That application is an ancillary application. There are many other applications like that you bring while there's a main action. If you raise an exception, that the sheriff don't have to go and serve that, because there's already an action that the defendant knows about. So then that attorney can serve that. I don't know if that answers your question, Miss. Okay, thank you. Right. Any other questions? I'm moving to the next slide, where we come to the officials of the High Court. Right, now, the first official of the High Court is judges. Does anybody know how judges are appointed?
You're talking about the whole process, or they're appointed by the president, but based off a recommendation list that's supplied, and then the judges are interviewed by the JSC, who then submits a list of recommendations to the president, and then he will then appoint from that list.
Yeah, you're right. Your notes say that judges are appointed by the president from the ranks of senior advocates, senior attorneys, and senior academics on a recommendation by the Judicial Service Commission. Well, it's not just senior. I've seen many junior people also being appointed as judges, and also not only attorneys, academics, and advocates, but also magistrates recently have been appointed as judges. So there you go. Do you know what are the qualifications that you must have in order for you to be a judge? Okay, the Constitution says that in order to be appointed as a judge, you have to be appropriately experienced and qualified. Yeah, that's about it. It doesn't say what qualifications you must have. It doesn't say what experience you must have. So I think that depends on the Judicial Service Commission of the day. Because remember, they make up the requirements as to what they want people to comply with to be appointed. A fit and proper person, yes. Do you know what a fit and proper person is? Miss Sakele, or sorry, is it a man? Kwanele Sakele, let me rather say the name. What is a fit and proper person? Okay, a fit and proper person, you are going to, when you're going to apply to be admitted as an attorney of the High Court, in your application, you will have to also persuade the court that you are a fit and proper person, because that is a requirement also to be a legal practitioner. You must be a fit and proper person. So what does it mean? Basically, it means that you must live not an honorable life, but an exemplary life. If there are some of you that's sitting and wondering if you're fit and proper because you have a conviction, previous conviction, I've seen people who had convictions be appointed. All you have to do, if heaven forbid that is one of your worries, when you were young, you shoplifted or you participated in some activities that you're not supposed to, and you were arrested and convicted, or you paid a fine, and that is going to come up. All you have to do is be open about it. Tell the court the details, and if they have questions, they will ask further questions on it. But it won't be a bar if you can demonstrate that you have now completely rehabilitated and you're not that person anymore who go go and robs other people, then you will still be admitted. So don't worry about that. Fit and proper means how you are at the moment when you apply. Okay.
Can I ask a question?
Yeah. Yes, you may.
You just said something very interesting. You said even some magistrates can become judges. So my question then is, in terms of the qualification, right? Does what makes a person a magistrate? Does that person have to have certain qualifications as well as the particular experience? Because that, for me, just sounds like any, legal practitioner can just apply to be a magistrate and be chosen as one or be appointed as one.
For the magistrate, I know you have to have an LLB. That's as far as my knowledge goes. You have to have an LLB degree to be appointed as a magistrate.
So but to be really a judge, your articles, you no, don't have to be admitted, rather. Sorry.
No, you don't have to be admitted as an attorney, because remember, some of the people who are magistrates have been admitted from the ranks of prosecutors. And prosecutors is not necessarily admitted attorneys. They went through the prosecuting training program and they became prosecutors, but they're not admitted attorneys. And some magistrates are appointed from their ranks. In fact, in the past, it used to be always from the prosecutor, you go up in the ranks of prosecutor and then you would become a magistrate. But now attorneys and other people also apply to be magistrates. Yeah, so you need to have an LLB to be a magistrate, but you don't need to have an LLB to be a judge. Now, having said that, I'm going to qualify that I don't know of any judges who has been appointed who doesn't have a legal qualification. But I just want to point out that it is not a requirement to have a legal qualification to be a judge. The JSC have their own requirements of what needs to be, and it can change as the JSC changes. I mean, they decide, and they only make a recommendation. They don't appoint you. A lot of, most of the times, the president follows their recommendation, but not always. Remember, with the appointment of the Chief Justice, the JSC recommended the Deputy Chief Justice of this, but the president didn't appoint the deputy. He appointed Chief Justice Zondo. So it's a recommendation, and you don't have to follow. Sometimes they make recommendation for Constitutional Court judges appointments, and then he makes no appointment. So they do the work, and he makes the final decision. Yeah.
Thank you. I'm just very intrigued by the fact that prosecutors are not really admitted, because I think I'll speak for self, is that we want to be admitted because there's a rank that you think you have to follow, or the process that one must follow is that being admitted and maybe be this great lawyer, and then ultimately try to get into being a magistrate, and ultimately try to be a judge. So it really doesn't have to follow that line. I'm quite intrigued by that, but thank you so much. I really appreciate it.
Are you a prosecutor, ma'am?
No. I'm a candidate attorney. I'm just serving my articles.
Oh, because I've had prosecutors do this. We have prosecutors, we have ex-magistrates. For them to become attorneys, they must go through this process of passing the board exams, of doing articles to become an attorney. That doesn't count towards anything.
Oh, wow. Thank you so much. Interesting. Thank you, ma'am.
Yeah. Okay, the next, if that is all about judges, then that's that. Okay, we get different kinds of, we get the normal judges of the high courts. And like I said, if you're a judge in a local division, you're still a judge of that division. Each division have one judge president. For example, the judge president of Gauteng is Dunstan. Hey, why can't I remember his surname now? Mlambo. Yes, now what they do if they have more than one local division, they have a deputy DJP, DJP, a deputy judge president, who is in charge of that local division, but he reports to the judge president because all of the judges belongs to that same division. And you would see that sometimes judges sit at the local division or sometimes they go to the provincial division. It doesn't make a difference. They're still doing their work. It's just that they go to a different office that is further away. Yeah. Okay. Okay, Cora, yeah. I take heed of what you said. Right, the registrar. Now, the registrar of the High Court is the most senior official in the Department of Justice at a specific High Court, and is the head of the court administration. Every High Court has a registrar. The pleadings are issued by the registrar, now obviously not by the person appointed as the registrar, but by deputy registrars and clerks that are employed. But he is ultimately the person, he or she is ultimately the person in charge, right? The registrar also is in charge, or the custodian, as they say, of all the court files. So if you file a matter, the registrar is the one who is looking after those matters, after those files. Okay. But behold you, if you're going to come to court and there's something missing in the file, you can't say, but it's the registrar is in charge, they must see to it that everything is in order. No. It's still you as the attorney who is responsible to see that your court file is at all times in order, especially if the matter is going to be before a judge. That you can't say, but I have filed this and that document and it's not in the file. They're not interested. You're supposed to see that everything is there. Okay, here's a whole write-up about prosecutors. The sheriff of the High Court, I told you about him. He's the next person, official of the High Court. The sheriff are the executive office of the courts. They are appointed in terms of the Sheriff Act. And the High Courts have a sheriff and the lower courts have sheriffs. He performs all the actions to do executive functions like serve processes. Also, if a writ of arrest is issued or a writ of execution is issued, the sheriff is responsible for that. Okay. Is there anyone that is a sheriff here? Because I always seem to have a sheriff or two in the class. Are there any sheriffs here? We won't ask you for favors. Right, then we have the taxing master. Now, the taxing master is an office of the court. He works in the office of the registrar, and he must see to it where cost is awarded, that the cost complies with the provisions of the rules. Now, let me just stop there for a minute. I don't know if you already did costs or if you looked at any videos with costs or anything. But you will know. Yes, you've done it. Okay, so you know what I'm speaking about. You will know that in all litigation, costs follow the cause. What that means is that the successful litigant is entitled to his or her costs. Right. So if cost is awarded against you, it means you're going to have to pay the costs of your opponent who was successful. Now, the cost that you are going to pay is not going to be the cost that your opponent paid his attorney when he went to his attorney and he said, look, will you do this matter for me? And they came to an agreement as to what the hourly rates are and how much work is involved, and whatever that amount is, that is between them. If cost is awarded against you, you're not responsible for that cost. The cost is contained in the rules. Rule 70 tells you what the cost is that you can claim if you are successful, or the cost that you must pay if you are successful. And it's much less than what the attorney and client's contractual case is. So if you are successful, it doesn't mean you get all your costs back, but you get some of it back. Now, the cost is usually for the client. It's not for the attorney. So you pay your attorney for whatever work is done. And afterwards, when he claims the costs from your opponent, that costs come back to the client. Right. Now, when costs are claimed, cost must be reasonable and it must be fair. For example, you know that bills of costs and what is it? Look, allocateur and all of those things that you say you've done. You can't just charge unreasonable time. You can't put unreasonable time in. You must use the tariff, but you can't say it took you a day to read a letter. You can't say it took you 5 hours to read 2 pages. That is unfair. So that is why when cost is awarded, the opponent would, in many cases, ask that the bill of cost be taxed. Then the taxing master, this officer, he looks at it and he will decide what is reasonable and what is fair and whether it complies with the rules. So if it is not fair, he will mark it down and say, okay, this is fair. Took you 10 minutes to read that. This couldn't have been that. Yes, the losing party pays the cost, but there are exceptions. But in all cases, in most cases, that is the general rule. The losing party always pays the costs unless the court decides there's the reported cases that costs should not be paid because they had a valid claim and it was an interesting matter or constitutional matter of value, or unless the party who wins misbehaved during the whole procedure. When I say misbehaved, I mean he didn't follow the rules. He was late with his stuff. He didn't do what he was supposed to do when he was supposed to do it. Then you can apply that cost that he should not be entitled to his costs. So depending on the circumstances, but then you'll have to prove to the court that this is an order that the court should make. The court can also, sometimes if a defendant, if he loses, but he also didn't come to the party, wasn't cooperative in that, make a punitive cost order, cost on an attorney-client scale, which is a higher scale than the one that is allowed in terms of the rules. So but you would have to ask the court to make that kind of a cost order. Okay? And then obviously the worst kind of cost order is the de bonis pro pris cost order. Because remember, it's not you, the attorney, who pays the cost, it's your client. But with a de bonis pro pris cost order, it is the attorney who pays the cost out of his pocket because the court is convinced that this attorney didn't do his work properly. And why should his client be punished for his sloppiness? And then the court can make an order against you. Obviously, you get an opportunity to address the court as to why such an order should not be made. Otherwise, it would be unfair if an order is just made against you. You can argue against that. But cost de bonis pro pris, yes, the court can make that. It's usually against attorneys, and I again say usually, because not so long ago, there was a matter of medical negligence in the High Court. And it was clear right from the beginning of this matter that this matter should settle. And parties, people at the department did not settle the matter, did not give instructions for it to settle. The matter started, and then only did they come forth with a settlement. And the court said that because they have delayed unnecessarily, because one of the things that some of you might know about the High Court is that you wait very long to have your day in court. From the time when you issue your proceedings, when you issue your summons, up until the day of the trial, I think they are now trying to make it within 18 months, but it's still more than 2 years that you get your day in court. So if a matter is settleable, should have been settled, there's really no defense, and you still go to court, the court can get very angry. And in that matter, the court got angry, and the court said not even the attorneys, but he actually made a de bonis pro pris cost order against officials of the department. That is how far the court will go to get people to do what they were supposed to do. The Baywatch principle in public litigation. Does anybody know the Baywatch principle in public litigation? Yeah. Look, the Baywatch principle, it is exactly what I said. In deserving cases in the court, don't make a cost order against the unsuccessful litigant. That is as far as I can tell you about the Baywatch principle. Does anybody know more about it? Okay, I've used it once and I forgot. I just know that the court don't make a cost order because it's a deserving case. The state is usually the party, yeah. And no, it can be a litigant also. It can be not a litigant. It can be what do we call, a lay person, or a normal litigant, not the state. Did any one of you ever deal with that? None of you. Okay. I do have, it's in constitutional matters. It's a Baywatch, not Baywatch. Okay. The purpose of the Baywatch principle is to shield unsuccessful litigants from the obligation of paying costs to the state. Yes. So an unsuccessful litigant in litigation against the state, if they don't win and the state wins, the court won't order that it's a Baywatch principle. It enshrines the right of all people in South Africa and affirms the democratic values. Yeah, that is what you can do if you have Google, eh? A tip, if you're in court and the judge asks you or the magistrates ask you something, you can quickly excuse yourself and go Google the answer. Yeah. Any more questions? I can't see. Oh, yeah. Cost orders are awarded against Baywatch, yeah. And Arthur versus Outer. Yeah, it was quoted in R2 versus Outer, but Outer is administrative law, as far as I know. Yeah, it's the Baywatch case. It's just litigants who are unsuccessful against the state, and if it was a deserving case, it must be a constitutional matter, and in deserving matter, then the court won't say that the unsuccessful litigant can pay the cost, because the normal rule is that the unsuccessful litigant pays costs. Right. Can I move away from the taxing master to the next official, the family advocate? Are there anyone here in class that works for the family advocate? No one. Family advocate. In terms of the mediation in certain divorce matter, do you work for the family advocate, ma'am? Sikungu. So you can tell us about the family advocate, but you say your reception is bad. The family advocates are employees of the Department of Justice. So they are admitted advocates of the High Court. And what their function is basically is in all matters where there are minor children involved, they recommend to the court whatever decision the court is about to take or may be asked to take in any relief requested from the court, that it is in the best interest of the minor children.
Alex Mays, 42 years old.
Okay, I don't know if other people could hear, but I just heard sound. I couldn't hear you.
No priors, clean as a whistle. I went to Boston College, got a BS in computer science. I
think someone's on TikTok.
Oh, it's nothing to, I thought it was the person telling us about the family advocate. Okay, so the family advocate is then acts as
went to MIT,
court.
I got a master's in computer. American Springville 6.
I hear American accents, yes. Can that person please refrain from... Yeah. Look, if you want to go and watch TikTok, it's fine, but just do it so that we don't watch it with you. Those of us who wants to be here. Whoever that is listening to TikTok or watching movies, I'm going to find you now. It's Christopher McCorney. Your microphone is on. It's not you.
Can I chip
Your
in?
microphone is... Hey?
May I
Excuse
chip
me?
in? You wanted to ask something. May I please chip in?
Yes, you may. Is it Christopher?
Yes, this is...
Oh, that's why your microphone
No,
is on.
it's
okay,
not.
Yes.
It's Malipole.
I just switched on mine now.
Malipole,
You mentioned my name.
I wanted to... No, I was saying on the chat that my reception is very bad, but I wanted to comment not necessarily on the family advocate front or aspect of the lesson. I wanted to chat, to comment on the BioWatch judgment or that I wanted to say that we are a public interest law center, so we regularly get similar judgments, sometimes even if we kind of like lose a matter, but the High Court generally doesn't award a cost against us. So coincidentally, we just had one delivered today and we somehow lost, but then we were not awarded any cost against us. So just wanted to comment on that.
Thank you very much for that. So you know, it's where litigants, even if there are some, I see how you speak like a lawyer. You don't admit that you lost. You kind of like lost, or you somewhat lost.
Yeah, we didn't lose basically. Yeah. On that note, that is what this is the first one after 10 years of like hold the Department of Basic Education accountable. But yeah, we never lose. But again, I'm gonna say we've not lost. You know, we are going for it again. All right, thanks.
Okay. Thank you very much, sir, for that contribution. Mr. Dirks, yes.
What about in the case of indigent litigants? Let's say, for instance, a case where legal aid represented somebody, and is it possible for them to get a cost order or something like that?
Indigent litigants that is represented well with legal aid, the court I don't think the court makes a cost order against a litigant who's represented by legal aid, and the reason why and this is what I think is that legal aid, before they take on a matter, they make sure that the matter has sufficient merits. So they're not going to go to court with a case that doesn't have merits. So if they lose, it would be marginally. It wouldn't be they lost, like, it would be somewhat like the guy said. They had a case, but it could have gone either way, something to that effect. I don't think the court makes cost orders against people on legal aid. I am not 100% sure, but I think they could argue that costs should not be made because they are indigent and they are represented by the legal aid board. Yeah.
All right.
But I'm speaking off the top of my head. Is that Mr. Dirks?
Yeah.
Okay.
It's Mr. Akas.
Mr.
Akas.
Okay. Fine. Mr. Dirks is also on. Is it the same person? Mr. Dirks, the microphone is on.
Advocate, my mic was off.
Is it? Are you Dirks? Your mic is on here by me.
Advocate, maybe yours is outdated because you also said mine was on when it was off.
Yeah, I think mine is very wrong.
Okay, no, it's fine.
Yeah.
Okay.
Because I can't seem to yeah. Okay. Can we move on? Okay, the family advocate. He must be known in all matters, he or she must be known in all matters where minor children are involved, because he must make a recommendation to the court as to whether the relief sought could be granted, and if it is granted, if it would be in the best interest of the minor child. Again, it's a recommendation to court. The judge is not bound by what the family advocate recommends. The judge relies on it heavily, because the judge can't go out themselves and go and investigate whether the decision is going to be in the best interest of the minor children. Remember, the High Court is also the upper guardian of all minor children. Now, what that means is that the High Court must always see that every decision that it makes would be in the best interest of minor children. And when the family advocate recommends something, and you are appearing for a client against whom this recommendation might work.
Speaking.
Lucia, your mic is on. Counsel, are you still with us?
Zuki, is the lecturer still on?
He's out.
Oh, great. I thought it was me on there.
I'm sorry about
Azukiswa.
I'm here. Sorry. Can you hear me? Hello.
Yes, advocate, you are audible.
Sorry about that. I thought I was still speaking and then I was gone. Yes. Where were we? By the family advocate.
Sorry, advocate. What time are we taking a comfort break?
At 7. It's almost that time. Let's take the comfort break now and come back. It's 15 minutes sufficient for you to get a cup of tea or something quickly?
Yes, it is.
Yes, thank you.
Okay, let's be back at 7:15.
Thank you.
Okay.
Guys, please mute yourselves while we're on the break.
Sandile, mute yourself. Sandile, can you mute yourself?
Okay, we're back. It's now 15 minutes past 19:15. Yes, I have in the meantime tried to share with you. So some of you may see it. I don't know, some of you may still not see it, but does most of you see the slide?
Yes.
Yes, we can.
Okay. Yes, thank you. Right, so we were at the family advocate. So we are, yeah, like I
Sorry,
said,
advocate, you are flighting the guide. Are you flighting the slides or the study guide?
what does that mean?
I'm seeing the study guide. Our manual is what I see on screen on page 13.
No, I'm not. I'm not flighting that. I'm flighting the. I got it wrong then. Hey, I think I'm sharing the slides.
No.
I think I'm sharing the slides. Oh no. Let me see again. Okay, let me go on. After the family advocate, the next official is the interpreter. Now, in civil matters, you must always, just want to close the guide then. In civil matters, you must always, when your witness needs to give evidence in a different language, it is incumbent on you as the attorney who is calling that witness to see to it that there is an interpreter to interpret for the court. For example, say if your witness is a Chinese person who speaks Mandarin, then it's important evidence. Remember, you must place the evidence before the court. It is for your client's pocket. You must get that interpreter to come and interpret. Now, interpreters are also appointed by the court. They are also officials of the court. They interpret what is being said. They don't necessarily, they don't translate. What they tell the court is their interpretation of what is being said. Okay, there's a noise. I don't know if it's me or if it's just a noise, but I can hear a noise in the background.
It's Quinta. Quinta.
My bad.
Are you playing cards? It sounds like shuffling
I'm
cards.
typing. Sorry.
Yeah. So
The slides were up. Sorry, advocate. The slide was up just now and then it went blank again.
Why did it go blank? Hey. This thing. Okay, so that is the interpreter. Then the next official is the court orderly. Now, in the High Court, the court orderly, he's also dressed like the rest of the court staff. He's also got on a white shirt and a black gown. He's the person who will call out names in the court, come to you if you want to hand up a document. You will come forward in court. You don't go and hand a document to the judge. The court orderly will come to you and take it from you to the judge. Are we up again?
Yes, we can see your slide,
yes,
advocate.
we can see it.
Finally, I hope it stays on. Sorry about that. Right, so that is what the court orderly does. In the High Court, they would also usually go and call the judges. Now remember, the High Court starts, the court day starts at 10 o'clock. Now, one of the ethical rules is, and this applies throughout to all courts, magistrates' courts as well. If you are going to appear in a court, you have to go and introduce yourself to the presiding officer before you appear in his court. Okay, So you can't just appear and you've never introduced yourself. So the first time that you appear before a specific judge or magistrate, go and introduce yourself. You don't have to go every time you appear in his court, only the first time. If you are appearing in an opposed matter, then you must take your opponent with you, because you mustn't go alone to the judge. If you appear in an unopposed matter, you may go alone. And basically what you do is you just tell the judges, registrar, we call them registrars, they're actually the judge's clerk. You tell them that you come for introductions. But usually before the court starts, say about 5 to 10 or 10 to 10, the court orderly will come and he will say, is there anyone that wants to make introductions? So there's nothing to feel strange about, but it's a thing that happens always. So then he will take you to where the judge sits, and then you will interact with the judge's secretary or clerk, and then she will tell the judge, these people to me to introduce themselves, and then you will go and introduce. You just say, I'm so-and-so, I'm from that firm, and I'm appearing in your court today. That's basically it. If the judge wants to ask you more questions, he will. Sometimes they just say, see you in court. Since COVID these days, the judges you don't go to their courts, actually. They wait in the corridor, and they don't take hands in it. A lot of things have changed in COVID, like we all know. Just say who you are and shake your head or something like that. But introductions are still done. Different than in the past, but still done. So the court orderly does all that. In the past also, when people had glasses of water when they were speaking in court, the court orderly would take the jug and fill it up. These days, people bring their own water. That doesn't happen anymore. The court orderly will also call out the names of people that appear in court who is not present in court when the matter are called. So when a matter is called and the person is not present, the judge will instruct the orderly to go outside and call the person's name 3 times. And if the person is still not there, then the judge knows, okay, the person is not there. That is now when there was an indication that the person would have been there. That's that. Court orderly. In the match court, for those of you who do match court work, the court orderly's role is usually played by a policeman. One that said stand in court or silence in court. That, just imagine yourself that, but it's more formal, a more formal appointment in the high courts. The judge's clerk is the judge's secretary, right? Who does personal things for the judge, or typing, collection of law reports, and you usually would go to that judge before you, to that clerk before you go to the judge. Colloquially, we call them the judge's registrar, which is incorrect, but it goes on and on. We say that is the judge's registrar. Who's the judge's registrar? It's not really a registrar, but yeah, there you go. The court stenographer. Now, all our courts in South Africa are courts of record. So everything must be recorded, right? We are courts of record, so everything that is said in court must be kept of it. Now, the court stenographers, they usually sit behind this machine in courts. You would have seen it. There's lights and stuff on it. There's a CD or something in there. I don't know if they've changed now to a flash drive, but it used to be CDs. And everything, and they have earphones on, everything that is said in court is recorded. They would sometimes say that a microphone is not working. So if you've been to court, you would see that where the attorneys, where the legal practitioners, where they are seated, there are always microphones. I've seen a lot of people trying to speak into that, thinking that it would amplify your voice, but that's not its function. Its function is to record what is being said so that we can have a record of what was said in court. Okay, it doesn't amplify your voice. Your voice should be loud enough so that the judge can hear you. Right. That is the court stenographer. And usually these functions are outsourced. They're not employees of the Department of Justice. It's usually a company who has the stenography And if you want a record of the proceedings, that is now the official certified record of the proceedings, not your own record. If you're going to appeal and you need a record, you have to apply to them. There's a specific page that you fill in. They will then send that specific CD to the people who tendered for that function in transcribing the record. And then the record will be transcribed. It's very expensive, about 20 Rand or so a page. Imagine if a trial runs for a month every day. It's thousands and thousands of pages, so it's very expensive. But that is how that happens. And advocates, both are appointed by the through the Legal Practice Act. Did I go off again?
You back clearly.
Your slide is still on.
Oh, okay, no, fine. As long as I'm on. So the court stenographer, no, Bondi. Attorneys and advocates are appointed in terms of the Legal Practice Act, Act 28 of 2014, and it came into operation only in November 2018. Right now, when it came into operation, a lot of things happened. Because prior to that, attorneys were admitted in terms of the Admission of Attorneys Act, and advocates were admitted in terms of the Admission of Advocates Act. They are two separate acts. Now, the main difference between the two, attorneys and advocates, is the following. Advocates is a referral profession. What that means is that you cannot go as a member of the public directly to an advocate and ask him to represent you in a matter. You must go to an attorney, and the attorney refers the matter to an advocate if the attorney deems that it is necessary. So an advocate is a referral profession and cannot take work directly from members of the public. And that has always been the case. Before 2018, the qualifications to be an advocate was the following. You had to be a fit and proper person, and you had to have an LLB degree. And then obviously, what was also in the act was you had to be older than 21. Those were the only requirements for you to be admitted as an advocate. Then you had immediate right of appearance in all the high courts. Right, to be an attorney before 2018, you had to have a degree, PProc or LLB degree. You had to have done 2 years articles or a year and this course, PVT, and you had to pass a board exam, and only then could you be admitted as an attorney. Right? When the new Legal Practice Act came into operation, it makes provision now for advocates also to have to pass a board exam before they can be admitted as advocates. Okay, so not just everybody can be an advocate who has an LLB. You have to first pass a board exam, and you have to meet certain requirements. There's a reading list, and you have to find a mentor, and you have to do certain things. Okay, there's a hand up, Wendy Manuel. Yes, Wendy.
I just wanted to ask, I hear, I was reading somewhere, what trust account advocates that can actually obtain instructions directly.
Yes.
Yeah.
Yes, I'm going to come there. Thank you for that.
Okay.
Now, in terms of the new Legal Practice Act, advocates have to also pass an exam. And once advocates have now been admitted as an advocate, they can decide whether they want to be a referral advocate or whether they want to be a trust account advocate. Now, one of the main difference between advocates and attorneys was that advocates cannot take instructions directly, but that is actually just the effect of the real reason. Advocates were never required to have trust accounts, right? And because they were not required to have trust accounts, they could not take money directly from members of the public and keep it in the trust account. And also they were not required to have a Fidelity Fund certificate that should something happen to the money, the public would have recourse to the fertility fund and get their money back. Advocates were never required to have that. So advocates couldn't take the public's money without somebody intervening and taking it in case something should happen to that money. Then there would be recourse for members of the public. It was to protect the public's money. Now there is a third legal practitioner. It is an advocate who is admitted as an advocate, but who chooses to be a trust account advocate. That advocate must, in addition to having passed and be admitted as an advocate, also meet the requirements of running a practice. So in addition, the Legal Practice Council requires that advocate do accountancy and also, legal practice, that course. So those two courses you have to do if you want to be admitted as an advocate with a trust account. And then you can take money directly from members of the public, but you are an advocate. Okay, there's the difference between is still that the one is a referral and the other one is not a referral. Referral advocates, the traditional bars, like the GCB, who has the Cape Bar, the Johannesburg Bar, and all of those bars, the traditional bars that were always in South Africa since the legal practice began. That bars do not allow their members to be trust account advocates. They must remain referral advocates who get matters referred to them by attorneys. So they can't act without the intervention of an attorney. Okay, that is the bar that I belong to, that referral bar. Then there's now, since the new Legal Practice Act, there's a lot of other bars that got accreditation to establish themselves. Some even before the Act came into operation, like PABASA, you might have heard of that. Then there's the South African, Republic of South African Bar Association, there's the Gauteng Bar Association, there's the Pretoria Bar Association, Church Street Bar Association, the National Bar Council. There's a lot of other bars with different rules and different, was different to the traditional bars, but the new Legal Practice Act allows for that. And some of those bars allow people with trust accounts. I mean, if you want to be an advocate with a trust, you would have to find out where you can fit in. But the traditional bar remains, and they only allow people who are in the referral profession. Right, are there any questions? And now everybody's qualification is an LLB. In the past, only advocates needed an LLB. You could be an attorney with a BProc. A BProc was a 4-year legal degree, like the LLB is now. Remember, the LLB in the past used to be a postgraduate course that you did over 2 years after you've done your undergraduate degree. But that has changed now. And everybody needs a 4-year degree and need to pass the board exam. Now, if you want to become a member of one of the, and when I say traditional, I don't mean anything by it. I'm just trying to tell you what I'm talking about. If you want to join the traditional referral bar, you must still do their bar exam. Because remember, if you wanted to, even in the past, if you wanted to be a member of the bar, you had to do pupillage of a year and then pass the bar exams before you can be admitted as a member of the bar. So, yeah, that's the difference. In court, the dress code is the same if you appear in the High Court. Attorneys now have right of appearance in the High Court. Well, I say now, but it's actually very long. Now it's almost 20 years since 1995. No, not 20, 30. Since 1995, attorneys have a right of appearance in the High Court. If they have applied and you apply to the registrar of the High Court after you have practiced continuously after being admitted as an attorney for 3 years. It's not automatic. And then you're certified to appear also in the High Courts. Before 1995, attorneys could not appear in the High Courts. Only advocates could appear in the High Court. Any questions? No, and I usually get a lot of questions with the differences between attorneys and advocates and all of that, but You're fine with that, right? Then the next.
Sorry,
yes.
Advocate, it's Richard here.
Yes, Richard.
I just want to ask you, when you get that certificate as an attorney to appear in the High Court.
Yeah, right of appearance in the High Court.
The right of appearance, I think it's that Section 25 certificate. Is that certificate permanent? Once you obtain that, you've got it for your whole career.
Yes, it is 25 subsection 3. It doesn't say you must apply every 5 years or every 10 years. It just say you apply once. Yeah.
Thanks, Counsel.
Okay, sure. Yes, there's another hand, TB.
Advocate, I just wanted confirmation. I heard somewhere that when for pupillage to become an advocate, there's now a stipend. Is that true? That now you can get a stipend instead of doing your pupillage for free?
From who do you get the stipend?
No, so what happens is that the your principal would apply to the, I think it's the Fidelity Fund, and there's like a 7,500 Rand stipend that gets issued to the firm or to the principal for taking you on as a pupil or a CA.
Isn't that's I know about that, yes, but a lot of people have applied and not everybody gets it. That's what I heard. But the stipend,
Need is, they only give where there's need.
Oh, you must demonstrate a need. Yeah. The stipend, it was last month that we got a survey where they asked us questions as to, do we think that pupils should be paid while they do pupillage? And questions like that. It was like a survey. So it is not, it's not yet in operation that pupils will be paid. You see, the difference between a candidate attorney and a pupil is a candidate attorney works. He brings in money for the principal. As a pupil, you'll never work. Your mentor will never give you work, or you never go to court on behalf of your, it's not just the nature of an advocate's work. You wouldn't send somebody in your place to go to court and do a trial on your behalf and do something on your behalf. As a pupil, what you basically do is, and I'm talking now about the bar as I know it, you go with your mentor every day to court or with other mentors, and you get exposed to work. You read papers, you maybe do practice draft, your principal marks it and he says, okay, that is where you learn on the job. So they asked, and the nature of those questions that they asked was that the mentors must pay. I don't know how that is going to work and who is going to pay for that. So yes, pupillage, you don't get paid. It is a transfer of skills. It is a year, and you do it. It's a learning thing, and it's not just doing that with your mentor. The bars also give you training. So every day after 4, you get classes like this class or other classes in various aspects of the law. And you also get a lot of advocacy training. They're very big on advocacy training. How do you behave in court? How do you talk? They do a lot of practices with actual sitting judges participating as judges, and you get trained. Yeah. So the last I heard of it is that survey. It's not yet a fact, but there's always been bursaries for people who can demonstrate that they need for pupils. There's always been bursaries, and especially for as they said previously, disadvantaged candidates, you can always apply for bursaries, and there's always been bursaries. A lot of people do pupillage and they get bursaries where they get a huge, it's not a small amount of money. They get a monthly payment while they do pupillage, and they also get a start-up package. And a lot of the bars have these startups. When people start out, they assist them because of the transformation, and everybody has initiatives to show that, look, yes, we're transforming the profession. So there's a lot of those going around. So if you really are interested in that, just ask around, because there are bursaries and stuff like that also. But a stipend for everyone is not yet law. Yes, sir. Wendy?
So there's no like real difference between an attorney and an advocate in terms of if you are to be presented with facts, you can't decide whether this is something that should be referred to an attorney or an advocate.
Okay, just what do you just ask me? Tell me why do you ask that? Why do you say that?
I mean, in terms of the work, when you see when someone comes, whatever, it's a dispute or yeah, where they need legal advice, how do you know whether it should be attended to by an attorney or an advocate? So the difference between an attorney and an advocate is not in the type of work that they can do. It's purely in how they operate.
No, it is in the type of work that they can do. The very nature of the two businesses are different. An attorney's business is more like a general practitioner. They do almost everything. They do things that advocates don't do, like conveyancing, like debt collecting, right? And they can do more than one matter on a day. They can divide their day, arrange with the court, I'm going to be there this afternoon, I'm going to do that this morning. Advocates are required to do one matter at a time. It is against the rules to double book, to do more than one matter on one specific day, right? With the result that advocates are seen as, the longer they are in practice, as experts in certain areas if they've done a lot of those kinds of work. So if it is a specific field of work that the attorney doesn't spend a lot of time with because he does a lot of different work, then the matter is referred to an advocate. If it's drafting or if it's research, then the matter is referred to an advocate, because attorneys, because of the nature of the attorney's business, doesn't do that. But that doesn't mean that you can't have an attorney's firm who does research, who operates like that. It doesn't mean like that. But because people can walk in to an attorney's offices and say, look, I want to employ whatever, they should be readily available. And because of that, they would refer some of the work that requires a lot of research and a lot of time in court. Maybe it's the High Court and it's going to take them away from the practice for 5 days, because the High Court also have what we call a continuous role. So a matter runs from the beginning to the end. If you set it down today and you estimate how long, and that is how long you're going to be in court every day. An attorney necessarily can't do that. So once you're in practice, you will see the differences. It is subtle, but it is there. Attorneys don't want to be away from their offices that long. So attorneys would be more kind of general practitioners who sees a lot of people, but there are a lot of attorneys, having said that does specialize and that do a lot of high court work and also operate like that. But then they have other people in their office who's manning the desks while they are at the High Court. I don't know if I've answered you sufficiently. There's another hand. Whose hand is that? I can't see.
Hi, Advocate. I think it might be mine. I just wanted to comment on something. I think we, not to be funny or anything, we have a background, not from your end. We have a background of most of these things. I think these things we could have researched ourselves, like the interpreter. We know what the interpreter. I don't think it's necessary for us to ask the difference between the attorney and an advocate. We should have known this by now. I'm not trying to be funny or anything or smart, but I think we're wasting our time here. There's other things that are important we could have been, touching on by now. Thank you, Advocate.
Okay, yeah, I hear what you're speaking and I acknowledge what you're saying, but there are some people who've never had the opportunity to ask these questions. So I do hear, you know it, but I mean, everybody is not in your shoes. That's basically it. So when they ask a question about something, I said I'll try and entertain them. But I do take heed of you of us spending too much time on answering these kind of questions.
Advocates, we did cover these types of questions in the other modules that we covered. So everything that you've said up until this point, it has been covered. People have asked these questions, and so it's just getting a bit tiresome having to.
Okay, I hear what you're saying. So you had other lecturers as well.
Yes, advocates.
Okay. Okay, fine. Those of you who want to ask questions that you already know the answers to, just ask it for the sake of asking. Yeah, think twice before you're going to do that. Okay, so in the High Court, I'm moving to the next slide. If you don't have the slides, it's just a picture of the High Court, what it looks like. I'm just now going to give a few general remarks of court ethics. Now, I have ethics there, and somebody once had a huge problem because of that word, and I meant to change it. And every time I see it come up, I remember I need to change it to conduct in court and not ethics, because ethics is something different. But the book says, your manual says, remarks concerning court ethics. So I'm just basically going to tell you, you must be suitably dressed. You know the code of dress in the High Court. It is a black pants, a white shirt, not a black pants, a dark pants. It can be black, brown, navy, yeah. A white shirt and a black jacket, black closed shoes, women, no sandals, black closed shoes, and your gown, and then the bangs. And your jacket, your black jacket, must at all times be closed. The buttons mustn't hang open. I don't know if you've experienced this, but the judge will tell you when you get up and say, I appear on behalf of my client, tell you, I can't see you if you're not properly dressed. So see that you are appropriately dressed. They are very strict with that. Right. If you're going to have witnesses, ask them to also, with respect, dress with respect. Yeah. Some of the older judges still make an issue of dress code. I mean, with witnesses, you really don't have that much control. If you enter or leave the court, you must bow in the direction of the bench. Everyone stands up when the judge enters and when he or she leaves. Now, usually when the judge enters, before he or she sits down, you will bow in your direction. And then you will also bow in his direction. If you stand up to address the court, your opponent must sit. At no point must two people be on their feet at the same time. And then we call, in the High Court, we call the court, either you can say the court as the court pleases, or you can say my lord, or you can say my lady. Okay, you would have noticed that in the Constitutional Court, they call it Justice, Justice Zondo, Justice, what else is there, Machit? They don't say my lord or my lady. They've done away with my lord and my lady, but in the High Court, it is still my lord and my lady. Sorry. Yeah, that's what I'm going to say about ethics, because you probably know this also. Right, let's come to the pre-litigation stage. This is now the initial consultation where you are going to take instruction from the client, right? So imagine yourself sitting in your office as an attorney, and a person comes to you for the first time. Now, it is the normal communication skills that you're going to employ here. You're going to make the person feel at ease, and then you're going to say, how can I help you? And the person will tell you their problem. When they come to see you, they usually have a legal problem. Right? So your notes says, in your manual, it says that you must listen, let the person speak in their own words, listen, and then later on, after they've completed telling you the version in their own words and you've taken down notes, then you are going to fill the gaps and ask the legal questions so that you make out the substantive case. Okay, so listen first, and then later on, ask the relevant questions. Like, for example, if they say, I want a divorce and this and that, then later on you're going to bring it down to point by point what you need to make out that case. That is what I mean when you say you're going to ask questions, right? If you need to get an opinion of an advocate, you can tell your client they must pay for it, and then you can get that opinion. You just remember you have a responsibility to keep your client up to date with what is happening in the matter. And then file administration is different with each company. You are still going to do casework if you didn't do it already this year. And then you are going to get 2 cases, which you're going to do. Did you do casework already? No.
Not yet.
No. So you're going to do that, and then you're going to have the practical experience of doing that, right? So this is just note as to if you open a file, you must put all the details on there. Important for those of you who are doing articles, you would know you must note down all the time. You must have a time sheet, all the time spent on a specific matter. Okay, so just remember that even if the person just phones you, or if an email is sent and you read it, you must note that. Important for the costs of the matter, right? Now, once you have consulted, sometimes you send a letter of demand first, because you try to keep the matter out of court. Remember, we are now required to at least consider mediation. So let's start out with the letter of demand and see if the judgment debtor or whatever, or the defendant or the respondent, whether he's willing to settle this matter out of court. So in the letter of demand, you will state, it's a normal letter, and then you will state the facts that on which the case is based, and then demand payment or demand performance, and tell him the consequences of not doing that, that you will issue summons, right? So this you know from your civil procedure, when you send a letter of demand to place a debtor in mora, right? To claim interest from an earlier date, the prescribed interest, prescribed rate of interest, that is what you would usually claim if it's a debt where interest was not agreed on. It is currently it is the interest rate, what do we call it again? No, not the prescribed rate of interest that the Reserve Bank announces from time to time.
The repo.
Repo rate, sorry. The repo rate plus 3.5%. Okay, since 2016, this act came into, the Judicial Amendment Act came into operation in 2016, and it said that you must now ask 3.5% above the repo rate. The Minister of Justice usually promulgates the interest rate, but he couldn't keep up with the many times that the repo rate has changed, so they're not up to date, and it is not a requirement for it to be promulgated to come into effect. So just remember, when you issue summons, when the repo rate went up, the first day of the next month, that rate is the rate that you're going to charge as the interest rate plus 3.5%. Yeah, just remember that. You also send a letter of demand when the creditor intends to cancel an agreement or contract. If you're going to say that you intend to cancel, then you have to cancel it later on if they do not comply, or you can cancel it then in your summons. Okay, yeah, non-compliance, the agreement must be cancelled. Then to complete a cause of action. Now, you send a letter of demand. Now, we refer to it in practice as notices, because in the legislation, they are referred to as notices. I'm going to point out 2 to you, but it's not really a notice. It's really a letter of demand. The first one is in terms of the National Credit Act, the one that I wanted to refer you to. It's the Section 129 notice. So if you've entered into a credit agreement and the judgment and the person is in arrears or is not up to date, then you would send him a Section 129 notice first. And then you would ask him that he must pay the arrears or make arrangements to bring the arrears up to date, or refer it for debt review or to the credit ombud. And then he has a certain amount of days to do that. And if he doesn't do it, and I think it's 10 days, if he doesn't do it, then you can issue summons only. If you issue a summons before you've sent a Section 129 notice, then it is a premature summons because the cause of action was not complete. So to complete a cause of action in a credit agreement, you have to first send the Section 129 notice. Now, when this came into operation, it was in 2008, a lot of case law developed around this because the letter, this notice in terms of Section 129 is sent by registered post or delivered by hand. So when people were in arrears with maybe their bond repayments or the credit card or the motor vehicle, and they knew they were going to get this letter, this notice, they just ignored the slip that the postman brought to them, which indicated that there's a registered letter that needed to be collected. So when the matter was set down for default judgment, they go to court and then they say, but the cause of action is not completed because we did not receive the Section 129 notice. So what the courts then decided was that if it is sufficient proof that if the creditor gives proof attached to the summons, proof that he has sent the letter of demand or the notice in terms of Section 129, and it has arrived at the post office where the debtor resides, then it is deemed to have been served, even if he didn't go and collect it. So what the creditor do is he attached a copy of the letter, a copy of the registered slip, and a copy of the track and trace report from the post office website, which indicates that the letter arrived at the post office and the name of the post office would be on there, and therefore it is deemed to have been served and the cause of action is complete. Yeah. And then there's also case law around the domicilium et executandi, that is the address that you would usually in a credit agreement, when you enter into it, that you would supply as the address where you will receive documents and notices should a dispute arise. If it is delivered to that address and you've moved and you did not inform the creditor of your new address, it is deemed to have been served on you. Okay, provided that the court has a discretion. If the court is of the view that the judgment creditor knew or ought to have known that the person doesn't live there, the court won't accept that it has been served. But I mean, that is the discretion of the court. Usually, it is incumbent on you as part of the contract, as one of the parties to the contract, to alert the other person if you should change your domicilium et executandi. Another notice that you have to send to complete a cause of action is a notice in terms of the institution of legal proceedings against certain organs of the State Act. Now, this is if you are going to sue the government. Now, the organs of state, it includes national government, provincial government, as well as local government. So even if you're going to sue the municipality, before you issue summons, you must send a notice. Now, in terms of Act 40 of 2002, the notice is in terms of Section 3. In the notice, you must set out what is the cause of action and how much you want. The state then has 60 days in which to comply, and if they do not comply, or if they tell you in writing that they repudiate the claim, then only can you issue summons. Before, if you issue summons before that, then it is premature. Also, this notice must be sent within 6 months of the cause of action arising. So you have a 6 months period if you are appearing for somebody or representing someone who wants to sue the state, an organ of state. If it's later than 6 months, then the Act, Section 4 of the Act makes provision that you can ask the court to condone your non-compliance. Remember, this is not a rule. So you are applying for condonation in terms of the act, and it tells you when the court can condone the non-compliance with a rule. Okay, and it's 6 months since it came or ought to have come to your knowledge that you have a claim. There is a reported case of medical negligence where the person suffered damages because of a negligent operation that was on him, he was operated on, and the operation was negligent. He didn't obviously know at the time when the operation happened. It was only a few years later when he had problems and he went to go and see a specialist, and the specialist told him that when they conducted that operation, they made mistakes, they were negligent, and it was only then that he knew he had a claim against the hospital. And the court said it is 6 months since it has come to your knowledge, so it would be 6 months since the expert told him. Okay, and yeah, then you send the letter and you ask them, and then only can you issue summons. Okay, that is all got to do with the notice in terms of section 3 of this act. This is everything that I've said just in that form. This should be 60 days. It has changed. Are there any questions on that? The gentleman who earlier said that they do litigate against the state a lot, he probably has done a lot of these letters then. Am I correct? Okay, so just know, sometimes they do ask you to draft a notice in terms of section 129 or a notice in terms of in terms of section 3 of that act, 40 of 2002. Remember, it is a letter. It's got a beginning, a middle, and an ending. It contains all the relevant facts to prove, and also the amount, and it must be reasonable, because the whole purpose of the letter is to give the other party an opportunity to try and settle this matter out of court. Right. We now move on to the attorney's mandate, Rule 7. Now, the attorney's mandate, I just want to see what the notes say about that. I haven't looked at it for a long time. The attorney's mandate, you don't need a mandate in each and every case. The only time when you do need a mandate from someone is when they question your authority to act on somebody's behalf. Now, mandate is a power of attorney, a special power of attorney for you to act on behalf of someone. So if you're in court and somebody says, but I don't even think this person have the mandate to act on behalf of the party he purports to act for, then you have to prove, within 10 days, you have to prove to the court and to your opponent who questioned your right that you have the necessary mandate. This happened, in my experience, it happened a lot in road accident fund matters, where on the day of the trial, the defendant, which is the road accident fund, would call these attorney and say, look, what attorney is there that is now that is doing the matter now? Because on our records, this claim was lodged by 3 different attorneys, so we don't know which attorney actually holds the mandate. In that case, the attorney that is there must get a mandate from his client, where usually would say that I withdraw or revoke all previous mandates that I've given to attorneys, and I've now appointed this attorney to do the matter for me. Okay, so when it's questioned, you have to give it. Right. Right. So imagine yourself again in your consultation, right? Your client has now told you his problem, and I said that you're going to listen to him, and then you're going to later fill the gaps, because you as a lawyer knows what needs to be present for there to be a valid case, right? So the cause of action, that is now the set of facts that give rise to a claim that is recognized by law. Okay. So you must now sit and you must now listen. Does this facts that this person is telling me, is this a real case? Right. example, we have this picture here. There's the two vehicles crashing into one another. There's a collision. What would you think? And your client comes and he tells you, he collided in me and I want to sue him for the damages to my vehicle. What is the necessary questions that you would ask in order to ascertain whether you in fact do have a case? Right? First of all, what branch of the law are we dealing with? We're dealing with delicts. Right? Now, from your substantive law studies, we know that in the law of delict, there has to be 5 elements present for there to be a delict. So you would ask the relevant questions if any of it is missed out or not clear. There must have been an act in the sense of a voluntary physical act or omission on the part of the defendant. The act of driving the vehicle must have been performed negligently. The plaintiff must have suffered damages. The negligent act of the defendant must have caused those damages, and the amount of the loss has to be proved. So those are the 5 elements. Now you know the elements, therefore you are going to ask the relevant question. But did the act of the defendant cause your damages? You're not going to ask, is there causation, is there this and that, but you're going to ask the relevant questions to make it the cause of action. Right? And then I just even thought about something now because everybody's so quiet, and then I thought maybe I'm not on, so I just wanted to put my phone number. Should I not be on?
No, we can hear you, counsel. We can hear you.
Yeah,
You're
just
audible,
making
advocate.
Right. Okay. There's another cause of action. Your client comes and tells you, I've been bit by my dog. Or by my neighbor's dog, not by my own dog. What is the cause of action? You probably heard this. It's the actio Dei Pauperii. Here you have to prove that ownership of the animal vested in the defendant at the time of the infliction of the injuries, that the animal was a domesticated animal, that the animal acted contra naturam sui generis, that is contrary to his natural way of acting, and that the conduct of the animal caused the plaintiff damage. So you can claim then from the owner of the animal if that was the owner at the time when the animal bit you. Or if a horse kicks you or whatever animals people have that can cause damage. Right. Then, this is what you ask yourself. What are the facts of the case? Do these facts constitute a cause of action? And which are the essential facts to be proved to constitute a cause of action? So, client tells you the story, you need to know that, right? If it's a divorce, they must be married in order for them to get a divorce. You know, some people come to you, then they say they want to claim pension. They live together, and now the man is leaving them. They want to claim pension. They must be married in order to get those proprietary rights after the breakup. It's not a divorce. This is just, I'm not going to go through each and every one. This you can read. It's not in your notes. It was just me giving you ideas as to causes of action. It's contractual, and the one was delictual, and the different remedies. You will remember it from your studies at university. Divorces. In divorces, there are many causes of action that are all brought together. Like, for example, the custody is one separate cause of action. Maintenance of the children is another cause of action. The division of the estate if they're married in community of property or out of community of property, distribution of the assets, or if they are married in terms of the accrual, how that should be done. And if there's an ANC, an antenuptial contract, if there's specific performance of outstanding obligations that is created in that document, whether it must all be done. Forfeiture of benefits. So these are all the things that you would ask and that you would take note of during your consultation. Right. Yeah. Any questions on causes of action? None. Right. So the next aspect that you must take note of during your consultation with your client is whether your clients have legal standing. Also referred in Latin, it's locus standi. So you ask yourself, does my client have a direct and substantial interest in the proposed litigation? Generally, he would have, but just take heed of Section 38 of the Constitution, who allows you to go to court even if you don't have a direct and substantial interest in the outcome, right? And then, does my client have the capacity to litigate? Generally, natural and corporate person have the capacity to litigate. Right, so I've just put this up here to demonstrate locus standi. Right, you must have an interest in the subject matter of the litigation. So for you, in order for you to suffer damages, you must be the owner. So if the plaintiff, who is the owner of vehicle A, say the red car, claims damages from the defendant, who is the driver of vehicle B, he can't claim damages from the owner of vehicle B unless the owner's conduct was the cause of the accident. Okay. And we do know that there can be an instance that even if somebody else drove the vehicle and caused the damages, that the owner could also be held responsible. That is in the case where the owner didn't maintain the vehicle properly, and therefore the brakes failed or something happened and caused the collision. Then the owner committed the delict. Remember, it can be an act or an omission. So, yeah. But you can't claim as the driver of the vehicle, you can't claim for damages to your vehicle because you are not the owner. You don't have locus standi. Right? The counterclaim, the defendant, the owner can claim from the driver. Right? Did that. You must have a direct, it mustn't be too far removed, actual interest. It mustn't be abstract, academic, or hypothetical in the right, which is the subject matter of the litigation and to the outcome of the litigation. So you must have a interest in the litigation. It mustn't just be far-fetched, far removed. For example, if you hold shares in Standard Bank and I don't pay my credit card, it doesn't mean you can sue me now. That is too far removed. That is a stupid example, but I'm just trying to bring back a point. When I said that you must have a direct and substantial interest, remember Section 38 of the Constitution. We can act in the interest of another person who cannot act on behalf of themselves, or as a member in the interest of a group or class of persons, or in the public interest. Okay. Remember the case of Hugh Glenister when he took the government to court for disbanding the Scorpions? That was in public interest. He didn't himself have a direct and substantial interest. But because it was in terms of the Constitution, he could use that section. So that is the exception. Any questions?
No further questions, Your Honor. We find interesting.
Right. So I said, watch out for this, the capacity to litigate. Now, minors, if a minor is under 7, they cannot be a plaintiff. They must be represented by their parent or guardian. Okay. And if a minor is 7 years and older, remember your studies, I think it's first year, family law, infants and poobahs and mayor or major. Anyways, I don't know if you did it in Latin, but the infant under 7 doesn't have the capacity to act. So always will the parent stand in for him. If the child is older than 7, obviously, and younger than 18, which is a major, then either the parent can stand in for him or the child can actually be the plaintiff who is assisted by his parent or guardian. So then you have the choice. And if you, now, when you're going to draft documents, you start out with the citations. The citations is where you describe the parties. Now, I'm just going to give you an example of how you would cite a minor under 7 who is represented by the guardian or the parent, right? So the plaintiff would be the parent or the guardian, and you describe them. Now, Rule 17 of the Uniform Rules tells you what must be in a citation. It says the name, what else? The age, not the age, the name, the gender, and the occupation, and the address. Those things must be there. So it will be Clive Engels, an adult male plumber who resides at 112 North Road, Cape Town, and who is cited in his representative capacity as father and natural guardian of Rachel Engels, a minor female scholar who resides with the father at 112 North Road, Cape Town. Now, here is one thing that I left out. You would usually, when it's when you cite a minor, you would put the date of birth in, because litigation runs so long that by the time it comes to court, the minor might have become a major. But you usually would say Rachel Engels, and then in the brackets, date of birth, and put the date in, so that the court knows it's still a minor. Right? That is when the minor is under 7. If the minor is over 7, then you would put the plaintiff is Rachel Engels, a minor female scholar, because this is now if you've used the option of assisted by the parent or guardian. Then you would say Rachel Engels, a minor female scholar who resides at 112 North Road, Cape Town, and they will put the date of birth there also, who is duly assisted herein by the father and natural guardian, Clive Engels, an adult male plumber who resides at 112 North Road, Cape Town. Now, sometimes people, when they act on behalf of their children, they also have a personal claim against that same defendant. And then they would have dual capacity where they act on behalf of the child and on behalf of themselves. For example, medical negligence. The child is born and has cerebral palsy as a result of lack of oxygen during the birth process, and now the father is claiming. But he also suffered damages because of this, he had to incur medical costs, he had to pay for doctors, pay for this. So he also wants to claim in his personal capacity. So then he would say, the plaintiff is Clive Engel, an adult male plumber who resides at 112 North Road, Cape Town, and who sues here in his personal capacity as well as in his representative capacity as father and natural guardian of Rachel Engels, a minor male scholar. Okay. Costs with both assistance, that is now when the child is older than 7 and you use that option, and representation, the minor is still the litigant. The court does not easily give a cost order against the minor. Obviously, the minor don't have money to pay unless the guardian institute the action recklessly. He is not liable for any costs. Okay, so depending on whether he really have a claim, was he reckless? If he was reckless, the court can make a cost order against him. But usually when it's a minor involved, the court don't make a cost order against the unsuccessful litigant. If the minor has no guardian, the guardian refuses to act on the minor's behalf, or there's a conflict of interest between the minor and the guardian. For example, the guardian doesn't, maybe in the courts get that impression that the guardian is not acting in the interest of the minor, or the minor says the guardian is not acting in his interest. The court can then have a curator ad litem who will then stand in the place of the minor in legal proceedings, appoint a curator ad litem. Okay. Now we get two kinds of curators. You get a curator ad litem and a curator bonis. In this case, a curator bonis is not appointed, only the curator ad litem for the purposes of representing the minor and acting in the best interest of the minor during court proceedings. Okay. A lot of, in South Africa, we have, unfortunately, a lot of cases where children live with grandparents or other relatives and the mother and father is not in the game. They're missing. And if something happens to these children, these people come to lawyers and they want to institute proceedings, but you remember, they can't because they haven't officially been declared the guardian. The children just live with the grandmother. So we institute proceedings, you can do it. and you can have a curator ad litem appointed. Court, usually from the ranks of advocate, would instruct an advocate to be the curator. It's just you use the name, and if certain instructions is to be given or a matter is going to settle, you must then consult with that curator, and he must know everything of the matter and see that the best interest of the minor is being catered for. A minor may litigate without assistance when applying for a curator ad litem to be appointed, or where the court grants permission for the minor to act without assistance, that is when the minor applied, or when the minor applies to be married. Remember, if you're a minor, you need your permission of your parents to get married, that is under 18, but if you want to get married, you can apply to court, and for that application, you do not need your parents' assistance. And when a statute permits a minor to act in court proceedings, I don't know if it's court proceedings, but I know minors do have rights for medical treatment. A 12-year-old can give permission without the parents' consent. So I think that statute permits that. So we're still dealing with the legal standing of the people that you are consulting with, and you're looking at whether they have legal standing. And you must just look at the red flags and what more must you do as the legal practitioner before you issue. Right? People married in community of property need each other's consent if they're going to litigate. Right? So if your client is married in community of property, you must get the consent of his or her spouse, provided there are 4 exceptions. If the litigation pertains to the trade or profession of the person, then you don't need the permission of your spouse if you're married in community of property. Also, if it is for personal injuries that you are claiming, you do not need the permission of your spouse. If you are also, if the litigation relates to things that you separately own, separate from the joint estate, then you don't need their permission. And lastly, litigation between the spouses, you don't need the permission of the spouse. Okay. Then, still with locus standi, when a person is to be declared incapable of handling his or her own affairs. Right. Now, if a person is to be declared to be incapable of handling his or her own affairs, you have to bring an application to court. How are you going to know a person is incapable of handling his or her own affairs? They come to you, they look totally sound and sane, and they tell you stories. I don't know, unless the person do something crazy like getting undressed or something. There's not, it won't be clear at the beginning. But remember, if a person is incapable of handling his or her own affairs, they can't give you instructions to appear for them. They don't have locus standi. You have to have a curator appointed. Now, this process of the appointment of a curator is in terms of Rule 57 of the Uniform Rules. And I don't have it here. It's later, but I'm going to talk to it now. Right. So you go to court twice. The first time when you go, you have to go to court to appoint a curator ad litem. Curator ad litem stands in place of this person who is to be declared of unsound mind. Now, in this proceedings, this person is called the a patient. Call him the patient, right? And this person is not the applicant. The applicant would usually be a caregiver, a family member, a spouse. If the person is in a frail care facility or in an old age home, it can be the matron, it can be the superintendent of a hospital, it can even be the attorney who brings the application and who is the applicant. So the applicant then deposed to an affidavit, and in the affidavit he must then state the status of the person, and very important, he must state his relationship to the patient, and also that he claims no personal interest in the outcome of this application, right? He must also state the circumstances why he thinks that this person should be declared of unsound mind. And then, after the person, after that, you need to have approached people who would be willing to be the curator ad litem. So you would approach an advocate, because usually they appoint curator ad litems from the ranks of advocates, but it can also be an attorney, doesn't necessarily, it can be a legal practitioner. Who will stand instead of this person in court proceedings. And you would ask that person, will you be willing to be the curator ad litem? Obviously, if the person agrees, he must sign a consent form. The consent form is basically just the heading of the proceedings, and it will just say, I, and the name, hereby consent to be appointed as a curator ad litem should the court appoint me as such, and his signature. So you need that consent form. You would also need the consent form of a person who has been approached and the person who is willing to act as the curator bonis. Now, a person is declared of unsound mind. I forgot to say this. When they are brain injured, maybe, or when they are diagnosed with Alzheimer's or dementia, it happens to older people, and they suddenly can't handle their affairs themselves, and they have an estate that needs to be taken care of. They can't give anyone power of attorney to act on their behalf because they're not compos mentis. They don't have the legal capacity. So the court must then interfere here and appoint somebody. Okay. Then they also need, and this is most important, they need two medical.
Nontobego, please mute.
They need two medical practitioners. One of them must be a head doctor, a psychiatrist, or a neurosurgeon, or a neurologist, who independently say that they have recently chatted or examined the person, and that in their opinion, he's of unsound mind, he can't handle his own affairs. So two people must diagnose him independently of each other, of which one must at least be a head doctor. Then you have all of that, and you bring your application to court. Now, the court will then appoint a curator ad litem if the court is satisfied with the person who has consented. Once the curator ad litem has been appointed, he then takes over in the proceedings, and his main function is to compile a report, and in his report, he must recommend who is the most suitable person to be the curator bonis. Okay, so who he thinks is suitable to be the curator bonis. Now, the curator bonis is actually going to be the person who is going to be taking care of this person's estate on his behalf. Right. Like I say, when you do the first application, you have already approached someone who said they were willing, but that doesn't mean that they're going to take that one. Usually family members would want to be, and I've seen this a lot, especially in road accident fund matters where the person had brain injuries and they're going to make a big payout. Family members usually think they should handle the money, and they consent to be the curator bonis. But what happens is this: the master of the High Court, who is the official of the court that must be known in all matters relating to insolvent estate or deceased estates, as well as the appointment of curators. The master of the High Court must also receive a copy of the report of the curator ad litem. And the master of the High Court must agree with the recommendation made by the curator ad litem. And the master of the High Court must also say whether he requires security of that person who is going to be appointed as the curator bonis. Now, security to the value of the estate. So this is where a lot of family members fall by the wayside because they can't come up with security of millions of rand. And the reason why the master asks this is because the money must be protected for as long as the patient lives. And yeah, you have the curator bonis must also periodically tell the master what they have done with the estate. So the curator bonis have a lot of duties. He can invest the money, he can open business, he can do a lot of things, but he must report to the master as to what the estate looks like and what he has done. Also must see to the day-to-day needs of the patient. So the money's once the master has said that requirement, they must meet that. If they can't, then the curator ad litem will appoint somebody who can meet that requirement. But the master of the High Court waives the requirement of security if the person to be appointed as the curator bonis is an attorney with a valid fidelity fund certificate. Then the master will waive the requirement that they must give security. And then if the curator bonis is appointed, they then take over the estate and deal with the day-to-day things and expenses in consultation with caregivers and so on and so on. Then you go back to court, and what's added now is the curator ad litem's report, the master's report. You bring the application for the appointment of the curator bonis, and if he's appointed, he takes it over. Are there any questions on that? I know it's 8:30. No questions. You want to go? Okay. Let's see each other tomorrow. You can ask me tomorrow.
It's a review of the others that we did.
You did this already?
It's just a refresher, so we don't mind.
No, I don't understand. If you've done all this, then I'm a bit confused, eh? Then why am I still doing it with you? With who did you do this, and under what did it fall?
Council Abrams, if I must just maybe come in here. My name is Richard again.
Yes.
We've touched on this in the magistrates court practice.
Did you do magistrates court practice already?
Yes, and Advocate Donovan did. But yeah, so Donnie did touch on some of the stuff, and he referred to some of the High Court practice rules and some of the stuff that what you're referring to, and yeah, and maybe if I can maybe make a suggestion, and I see Sukis was still on the group, is maybe they should combine the High Court practice and the Magistrates Court practice together as one subject, maybe going forward.
We're expecting that to happen since the rules became the same, but nothing has happened since. We expected it to happen because really it's the same thing over and over again. Yeah, there's nothing I can do about it. So I'm telling you stuff that you already know.
But you don't mind to see you tomorrow.
We don't really mind. We don't mind.
It's a revision, it's fine.
It's good for us. Thank you.
Okay. Okay.
Good night.
See you tomorrow.
Good night.
Good night.
Good night.
Good night.
Good night.